What's going on? My name is Ryan Hamilton. I'm a succession and trust lawyer, and I service the entire state of Louisiana. Today, what I want to talk to you about is the difference between wills and revocable living trust. I want to focus in specifically on revocable living trust because I think those are most comparable to when you would choose one versus a will. I mean, there's all type of trusts that get more complicated, or irrevocable trusts, and effectively intentionally defective grantor trusts, and gun trusts, and pet trusts, and you know, just all type of stuff, right? Medicaid asset protection trust. You could do a bunch of things, but what I want to focus on today is the difference between a will and a revocable living trust, because I think they're basically the only two options that most people are going to want to do when it comes to passing your assets on to your children or your loved ones or whoever you choose. So let me start by just defining what each one is. So a will is basically a set of instructions that you're going to leave to the court to tell the court how you want your property distributed, who you want to distribute it to. You'll also name an executor. This person is the person that's going to go to court and basically bring the will and say, this is what he wanted to do, and I'm going to do it. I'm going to pass the property on to, the children or the siblings or, whoever it may be. So that's what's going on with the will. In a revocable living trust, you're not going to ever go to court. At least that's the whole goal of it, right? A trust is typically a three-party agreement where someone in a revocable living trust, typically you are all three parties. You are the person that's given property. You are the trustee that's accepting property on behalf of the beneficiary. And in this case, you're also the beneficiary. So what this does is this basically titles everything you own it takes it out of your name and puts it in a revocable living trust. So when you pass away, there's no need to go to court because everything is already titled in the revocable living trust. And there's also rules and instructions on how all that property is to be managed. Who's going to be the successor trustee? That's the person who's going to step up and control everything after the initial trustee dies. Also, who's going to be the successor beneficiary? That's the person or people who are going to basically benefit from the assets within the trust. So the revocable living trust, the main goal of it is to avoid doing a succession or avoid doing probate court. And people always want to, I'm not going to say what people always want to do. There's an idea that a will is cheaper than doing a trust. And that is true initially. While a will is under $500, in a trust is probably in the range of $2,500 to $3,500. What we're not including with the will, or at least what a lot of people forget to include, is that you still have to go to the probate court and do a succession, and that's going to cost $3,500 on the low end. And with a married couple, you may have to do two of those. So now we're talking about $8,000. If you have property in more than one state, now you're talking about additional fees twice. So you could easily see yourself getting up to $10,000 with not a lot of assets. Let's just say, you have a house in Louisiana, and then you have a couple pieces of property in Mississippi. That's basically two courts that you're going to have to deal with. Yes, there's a, abbreviated process for Mississippi. They're going to recognize that you've done a succession elsewhere, and that you just need to file that judgment, probably make it executory in that parish. But that's still a fee and a process that you may have to do twice. So the main advantage, I guess, if I want to give the will an advantage, I'm going to say it's simple. It's easy to do. It doesn't require a lot of work. You literally, a will probably only needs to be one page and say, I give everything I own to, my children equally. Boom. And I name my oldest daughter the independent executor. And that's what you want to do. You definitely want to have an independent administration should you need one, because it's a lot cheaper if you have to do that. Independent administrations limit court oversight. It gives the independent executor or executrix the right to sell real estate without first having to advertise it in the paper, then filing motions to get the court to approve the sale of real estate for whatever price it was listed for. So if you definitely want to do independent administration if you're going to do a will. It'll at least keep the fees somewhat lower. But if you want to talk about cost, the revocable living trust is more expensive up front. But in the long run, it's probably much cheaper. I could easily, in most situations, see, you know, doing a revocable living trust will be $5,000 cheaper than doing a will and probate, a will and doing a succession. So also, you have the ability to do things in a revocable living trust that you cannot do in a will. The main thing being is putting restrictions on, when distributions are going to be made to younger children. Maybe you have some younger children and you might have, maybe you have a lot of money, or maybe you have an insurance policy. For a large sum of money. Maybe it's $1 million. Do you want to drop off $1 million to an 18-year-old? Maybe not. You want to make sure they care for it. You want to make somebody's watching over them, but maybe you don't want to release the whole million to them at 18. Maybe you want to say, okay, certainly, you pay for college, or you pay for, living expenses and things like that. But, maybe you want to find a way to manage this money so this money will always be around for them. And you can set that up to say, hey, you can get this distribution at 18, this distribution at 24, this distribution at 30. So that's an advantage of a trust that you just can't get through a will. And then also, I would say another advantage with the revocable living trust is the elimination of going to court. You're basically doing it, you're front loading it. You're doing everything on the front end. So, your grieving widow or your grieving children don't have to go through the process of hiring lawyers and, spending money to actually do that succession at that time. And you eliminate it never happening. I mean, a lot of times, people take forever to do succession, and I'm not judging anybody. I'm just saying this is what it is. I routinely do successions for people who have passed away many, many years ago. I mean, 20, 30 years ago sometimes. So this is basically you just kind of guaranteeing everything's going to get done. You're taking that burden off your loved ones. I think that's probably the most important thing of doing a revocable living trust. If you really want to make sure everything's taken care of, then you probably want to do a trust. You're going to do everything. You're going to make sure everything's in that trust. You're going to change the name to all your bank accounts. You're going to change the name to all, any real estate you own, any properties you own, any stock accounts, any savings accounts, any bonds. All of that is going to get transferred over into the revocable living trust and get titled in the name of the revocable living trust, so you don't have to go. Well, not you, so your family members don't have to deal with doing a succession or going to court. That will just be nothing that they have to deal with, especially having to deal with it in a grieving time, in the time of grief. So that's probably the greatest advantage of just having everything in order and eliminating that need for anybody to go to court. And it is also cheaper. I don't know if that's a big factor for a lot of people, because we're talking about some expense that may be far off in the future. But at the end of the day, if you're a bean counter, would you want to save $5,000 to $10,000 possibly? I think so. I think a lot of people will raise their hand and go for that. So, that's pretty much. And then you get the ability to place those restrictions on distributions to children, but at a cost. I mean, that's something that's going to cost. So if you want to place restrictions on distributions to, a minor child or a younger child, you're going to need someone who's going to have to be who's going to be the trustee, to handle that. And maybe you can appoint, a family member to do that, and maybe they're willing to do that. But in most cases, you're probably going to wind up with a third party trustee doing that, and that's going to be somebody who's going to charge a fee. And the fee is roughly somewhere between 1% to 2% of the estate of the things that are in the estate yearly. And then I think there's something like a minimum of like $8,000 a year for some banks to do it if you're going to get a bank to do it. So, you're probably going to want a sizable amount of money, in the account if you're going to have a third party trustee. But that would be the case if you left $1 million. If you had a term policy for $1 million, which term policies for $1 million aren't that expensive. So I think that's attainable for a lot of people. I think you can get term insurance for, $1 million of coverage, possibly for about $50 a month. And so you may have a situation where, people always say, oh no, that's only for rich people. That's only for rich people. Well, if $50 a month is only for rich people, then I don't know what to say. I mean, people are spending $50 a month on all type of stuff, So, but that's neither here nor there. We're getting sidetracked. So, basically, I would say, to sum it up, the will, the advantage there is it's simple. It's not a lot of work. You could do it quick. You can get it done in the jam. You could probably show up to a lawyer's office and get a will done in a day or two. That's probably not going to happen with a trust. It's going to take some time to get that together for the lawyer to even draft the trust, because it's a lot more complicated, the things that they have to do. And then on top of that, after the lawyer has drafted the trust and it's been executed and it's been signed, and you've signed your name 50 times and it's been notarized all those times, and you got this big binder full of stuff, it's still a duty of you to then go and transfer everything you own to that trust that you have now, or it's useless. So if you do a trust and then you don't go do the next steps of titling everything you own, all your bank accounts, all your assets, all your property, brokerage accounts, things like that, into the revocable living trust, then basically your trust is useless. So I would say, to sum it up, and I've probably summed it up a bunch of times already, but the will is cheaper on the front end. I would like to stress that it's cheaper on the front end and it's less work on the front end. And hey, I can go run and get it, and maybe find a lawyer to do it for possibly $300 or something like that. And you've got some planning tool and you've done something for your loved ones. But if you really want to go take the extra step, you're probably going to save money in the long run by doing the trust, and everything will be everything will be much easier for your loved ones, and at the end of things. And so go talk to a lawyer and figure it out, or do some more research and figure it out. If you need to contact me, I've got a link in all of my bios on social media. It's RC Ham Law, and that's on Facebook, Instagram, YouTube, TikTok, all that. You can click the link and schedule a consultation.